you. All right, and we're now ready for our second argument with our slightly different panel. We now have Judge Toby Hampson on my right, and of course Judge Flood still here. So, all right.
Judge, I've reserved 5 minutes for rebuttal.
Okay, and that's already done. Very good.
May it please the court. I'm Hunt Wofford, and together with my co-counsel Rebecca Wofford, we represent Tracosa Green, who is the appellant in this action. We are asking the court to reverse and vacate the trial judge's order for permanent child support in this matter. In North Carolina, there are 3 classes of people who are subject to being ordered to pay child support for a minor. Generally speaking, those 3 classes of people are biological parents, adopted parents, or any other person or agency, organization standing in loco parentis who has voluntarily assumed the obligation to support a child in writing. My client, Tracosa Green, falls into none of those 3 classes. Nevertheless, at trial, the trial judge created a new class of parent for child support purposes, determined that my client was a member of that class, and ordered her to pay child support. The appellee in this case is named Ms. Carter, so when I refer to Ms. Carter, that's what I'm talking about. But Ms. Green and Ms. Carter, for several years prior to the birth of the minor child in this case, were involved in an on-again, off-again dating relationship. The relationship, I believe the evidence was, began in New York State, and during that time, they were together. Ms. Carter determined that she wanted to become pregnant by way of in vitro fertilization. Ms. Green supported Ms. Carter in those efforts, would attend doctor's visits with her, and at some point even allowed her insurance through employment to provide coverage to Ms. Carter under a domestic partnership allowance within that insurance policy. So Ms. Green provided the insurance coverage that Ms. Carter used for the in vitro fertilization treatments. At some point, the relationship ended, and Ms. Carter moved to Michigan, which is where the minor child was born. Thereafter, and the child was born on November 29th of 2016, which is important in this case given the dates of how the law developed in this area for same-gender marriage and things like that. So the child was born in 2016 in Michigan, and thereafter the parties separately moved to the state of North Carolina. On October 26th of 2018, Ms. Green filed an action for custody. She had to proceed as a third-party non-parent in that action. The trial court found that she was a non-parent in that action.
Well, let's stop right there. The trial court did not find she was a non-parent in that action. The trial court used defined terms, didn't it?
Not
it
in the
defined
custody
her
action.
as, it defined your client as, quote, non-parent, and Ms. Carter as, I can't remember, biological parent or whatever the
I
terminology.
think biological parent was the term, yes.
And so, but ultimately found that your client did, in fact, or essentially was a de facto parent, you know, sort of applying our, you know, Estroff, Mason, McLean, whatever, all those cases, that on the facts of this case, that your client had, in fact, kind of moved into that role as a de facto parent. So the mere fact that it's used, I mean, maybe it wasn't the most articulate defined term, maybe it wasn't, you know, the most helpful defined term, but that's all it was. I mean, it could have called, the trial court could have defined your client as a ham sandwich. It didn't make her a ham sandwich. It's just simply to delineate between the 2 parties. I mean, how do you respond to?
Well, ultimately, what the trial judge found, which is important, is that she was not a biological or an adoptive parent.
Sure.
And had to proceed as a third-party non-parent for purposes of obtaining custody.
And that's consistent with our custody law.
Which is consistent with the common law in this state and consistent with, as Your Honor said, the Estroff case and all the progeny thereafter that did use the term de facto parent. And what the trial judge did, which is important in that case, was had to look at the actions of the biological parent to determine whether the biological parent had acted inconsistent with her protected constitutional rights. And once the trial judge made that finding, then the trial judge was able to proceed to enter a custody order based on what's in the best interest of the minor child, as that is the law. That order proceeded, and then my client, Ms. Green, was granted some custodial and visitation rights. But at no point was my client found to be a parent in any way other than, as Your Honor stated, through the de facto parent standard that was set in Estroff and Mason and Price and those cases here in North Carolina. So thereafter, and while that custody action was pending, a custody action that, by the way, Ms. Carter denied all along that Ms. Green was a parent to this child and should be treated as a parent to this child. Ms. Carter filed her child support action. The child support action was consolidated into the custody action. And
I was gonna ask you about that too, because I noticed that the file numbers were different, and then the support order got entered in the custody action.
That's right. The custody action was filed first, and so under our local rules in Mecklenburg County, they were, and probably everywhere else, they were consolidated into the older case, which is why Ms. Green is listed as the plaintiff in this action.
Yeah.
And so after the child custody action was tried in 2019, the child support claim proceeded and was not tried again until 2 years later in 2021 under a new judge. A new judge had been assigned to our case. At that trial, the trial judge determined that Ms. Green was a de facto parent and proceeded along the lines of Ms. Green being a de facto parent, and actually made a finding in his order that Ms. Green is a parent to the minor child in the same sense that the heterosexual terms mother and father are used. This court finds it appropriate to apply those terms in a gender-neutral way. And that is where the trial judge erred in this case. The trial judge looked to NCGS 50-13.4 and decided that it needed to be applied in a gender-neutral way. And our argument is that 50-13.4 is already a non-gendered statute. It does not act in a gendered way. It does refer to mother and father, but ultimately it's talking about parents. And it provides for a delineation between those who are primarily responsible for the support of a minor child and those who are secondarily responsible for the support of a minor child. And that delineation comes up again in this court order because the trial judge found that Ms. Green was a primarily responsible party who would be primarily responsible for support of this minor child. And that was the error that the trial judge committed. Those who are primarily responsible for the support of a minor child under our statutes are mothers and fathers, or if we just want to generally talk about them in a non-gendered way, parents. And parents, the term parent is a legal status that our statutes provide for under our law. When it comes to defining parent, the statutes make it clear, and it's not just 50-13.4. There are numerous statutes that talk about how we're going to apply the parent standard or the parent classification to a party in a custody lawsuit or even a child support lawsuit. And those standards that the statutes talk about sort of cross the line both between a marital status between the parents and a biological status between the child and the putative father. The biological question is never, ever really asked when it comes to the birth mother for obvious reasons. But when it comes to a third party, such as the father or a male parent, then we have some biological testing that we can do. So we have biological parents. We have parents who are parents by way of marriage. You know, when you have a father who is married to the mother at the time of birth, the presumption is raised that he is the father, and there's no biological testing that's required unless there's some question of a putative father that's not a member of the marriage relationship. But ultimately, in this case, we don't have any of those standards met. These parties were not married. They could have been married. Their relationship began and ended after the 2014 Supreme Court case that made same-gender marriage available to all same-gendered couples. They lived in North Carolina at a time when North Carolina could have, or when they could have been married under North Carolina law. The child was born at a time when a same-gendered couple could enact an adoption method so that the non-biological mother could adopt the child and become a parent that way.
Is that,
So-
sorry.
Go ahead.
No, please.
Well, I was just say, so if they'd been married, under the statute that the child born to artificial insemination is considered the same at law as a naturally conceived legitimate child of husband and wife. It's 49A-1.
Yes, sir.
And of course, we have the statute 12-3, husband and wife can be construed to mean any two individuals lawfully married to one another. So if they'd been married, would that fall under those statutes? I realize they weren't. This is one of those hypothetical things.
That's a question that came up when we were doing the research for this, and while we don't have to answer that here, I
Right.
believe the answer is yes. I believe in that case, it would have been appropriate for a trial judge, if that case arises, that it would be appropriate for a trial judge to look at that statute and look at it in a way that needs to be gender neutral and that sort of thing as we've come to develop law in areas like domestic violence, because that would be consistent with the statute. Now, our argument, or with the spirit of the statute and the reasoning for the statute. So in that case, yes, I think that the law that case would result in there not being a question of parentage at that point. And then when a custody case came up, the parents would be on equal footing. We wouldn't have to do the constitutional clear and cogent and convincing evidence test. We would go right into a best interest issue. And in a child support case, those parents would both be primarily liable for the support of a child. I think that would be the answer, though.
So part of the reason Estrov and Mason, McLean, those cases arose when they did was because we had this issue, right, in the law, where we did have same-sex couples, IVF, and there was simply no mechanism recognized under our law for, at that time, single-parent adoption, those sorts of things. But clearly, at least in some of those cases, there was at least an argument that there were essentially parental relationships, right? So why then is sort of, I don't like calling it de facto parent, but the sort of this de facto parent doctrine, why does it not sort of necessarily follow that if de facto parent works in the custody concept when the statutes didn't cover that situation, why then doesn't that sort of track logically to the child support aspect of the case?
Well, because at no point in our years of doing the de facto parenting, or years of having the de facto parent standard in North Carolina has it been used in the child support realm. And
that doesn't necessarily mean it shouldn't be.
Well, except for the fact that child support is the realm of the legislature. And child support and the child support statutes have all been, that has been child support. Custody has sort of developed in this common law way with best interests and things like that. But child support has always been a realm of statute. And if we're going to allow a trial judge to declare somebody, it's not necessarily a domestic partner. They can be declared a de facto parent. If the trial judge can declare some third-party non-parent to be a de facto parent, then that would cause, it would be a negative factor for third parties to step in and try to help minor children who might need help. It would be under the statute, organizations and institutions could ultimately be determined to.
But isn't the concept of this idea of acts inconsistent with one's constitutionally protected status as a parent, that's a common law standard. So common law created the ability for your client to obtain some of the parental rights. Why then would common law not permit the requisite and commensurate obligations of being a parent?
I think that a distinction here that we need to make is when we're looking at the de facto parent standard in a custody case, we're looking at the actions solely of the biological parent. The non-parent can't do things to become a de facto parent that the biological parent doesn't allow. And you see that distinction early on in the de facto parenting because when the Mason and the Estroff cases were determined at the same time, the biological parent won one of those cases.
Right.
And was found not to have violated their constitutional rights. And in the other case, they were. So it is, in the custody realm, when you're looking at that de facto parenting, you're looking at only the actions, really, of the biological parent. The non-biological parent can't force their way into that without the biological parent doing something. And then to flip that and then require a de facto parent that may be determined based on the actions of the biological parent would be unfair to all the potential de facto child support paying parents out there.
But your client sought those custodial rights in this case.
She sought them because she saw a need for it with this minor child. She saw something that the minor child needed, saw a best interest that the minor child wasn't having satisfied at the custody level. The trial judge agreed, found that the biological parent was not acting consistent with her constitutional rights, and did that process. The trial judge couldn't find that our client, just by seeking those actions, had done what she needed to do to become a custodial parent. The trial judge had to find that the biological parent didn't, or did something else. And so that was the issue there. And the biological parent fought that along the way, fought the claim that my client had that she had acted inconsistent with her constitutional rights. We had to have a whole trial about it. So,
But isn't there, sorry.
Well, I was just going to try to get back to the statutes, because we've got different wording in the custody statute versus the child support statute. In the child support statute, we have father and mother primarily responsible for the support of a child. In the custody statute, we have different wording. One thing I think is interesting is the statute about a custody of a person incapable of self-support upon reaching majority. Under that statute, the custody laws still apply, but the child support doesn't, which I've always thought was the craziest thing I've ever seen. But that's what the General Assembly said. So if you could talk about the differences in the statutes.
well, as Your Honor said, I think that the reasoning behind the child support statute is one of the ideas is to look at the history of that statute, how it's changed over time. And, early versions of the statute, listed parties in order of responsibility, with father being first and mother being second, and then institutions that may go along. So I think that one of the reasons for the differences in the statutes these days is sort of the history of both statutes. I don't know that when the original custody statutes were written that the word parent was used any different or anything like that. But, the custody or the child support statute is written for the purpose, I think, and used for the purpose, I think, of literal financial support for minor children. And it provides a way for parties to do that outside of the marital relationship when you're talking about third-party institutions and that sort of thing. But it limits those types of obligations and limits that type of child support between primary and secondary support in that way. And I think really when we're talking about the differences between these two statutes, the reason is they've sort of developed over time in different ways. And I don't know that there's any specific motivation on the part of the legislature or anything like that when it comes to using different words in different statutes. I think that's just the way it developed. I think an important thing to do here when we're talking about gender-neutral interpretation of statutes is to look at what that really means. In this case, I think the court looked at a same-gendered couple and thought that gender-neutral means one thing that it really doesn't. Gender-neutral interpretation of statutes is meant so that results will be the same under that statute regardless of the gender of the parties. That's what the gender neutral means. And so, the best example of that is in the domestic violence statute. When you look at a couple who is together, who is, there's a domestic violence issue within that couple, whether they're a married couple or not, to have read that statute in a way that limited its protection to men and women would not have made sense under the spirit of the statute. But if we look at the child support statute and we think about how it will be developed under a gender-neutral way, we think to ourselves, what if Ms. Green was Mr. Green? What if Mr. Green and Ms. Carter had been together in a dating relationship and then split up prior to the birth of the child or even after the birth of the child? And what if their relationship had developed the exact same way that Ms. Green and Ms. Carter's relationship developed and ended in this case? Under the statute, I don't believe that there's much of a question that Mr. Green would not be required to pay child support. He may have still been able to obtain some custodial rights under the constitutional argument that Ms. Green was able to succeed under, but he would not be, nobody would intend or nobody would think that he would be obligated to pay child support in that case because he would be a non-married, non-adopted parent to that child. At best, he could be a third party acting in loco parentis here and there, but that's not what happened here, and it's not the findings of the trial judge in this case. Remember, the trial judge in this case found that Ms. Green was primarily responsible for the support of this child, and the only parties in North Carolina under the statute who are primarily responsible for the birth or for the support of a minor child are biological parents and adopted parents. That's where we are. Any change to that would need to be done by the legislature. And to make those changes to the statute would be stepping into the bounds of what the legislature is entitled to do. I still have some time left unless there's other further questions. I was going to sit and wait for my rebuttal.
Well, let me.
Yes?
So, is there not an element of of judicial estoppel that comes into play here, in that you prevailed on the custody aspect, prevailed on essentially the de facto parent aspect to obtain custodial rights? How then do you sort of take the opposite position, that for purposes of child support you're not a parent? I guess that's the question. Does judicial estoppel between the custody action and the child support action come into play here?
I don't believe it does, Your Honor, because that would, in that sort of a fact pattern, you wouldn't be able to limit those types of obligations to just same-gendered couples. You would have any third party that had the ability or the desire or the need, whether the third party is an individual, a grandparent, a county domestic or a county child protective services group that could come in and act in loco parentis and assert custodial rights over a child. They would then be subject to some sort of judicial estoppel and child support obligation under that kind of a broad, powered ability of a trial judge. So we need to limit this child support obligation to the statute. We need to let the legislature make its changes if any changes are needed.
Thank you.
Good morning, Chief Judge Stroud, Judge Hampson, and Judge Flood. May it please the court, my name is Rebecca Watts, and I'm here today on behalf of the defendant appellee, Ms. Carter. The issue we have here before you today is whether someone who does not share a biological or adoptive relationship with a child can still be considered a mother or a father for purposes of child support. It's our position that when two people make a conscious decision to create a child together, that child deserves to receive financial support from the two people responsible for that child's conception and birth. Our current law is oriented toward children who are born as a result of sexual intercourse between a man and a woman, but the reality is that many children are conceived and born through other means. And if we believe if two people engage in sexual intercourse and a child results, and we're going to hold both of them responsible, whether they're married or unmarried, and they're both accountable for child support, even if they didn't intend to create a child, we're going to hold them both responsible. So if we are going to treat children who are conceived through assisted reproduction, when both people consciously are choosing to create a child, if we say these children are not entitled to support, then we're giving these children a different status than children who are born through sexual reproduction. How can we then say they are both not responsible for child support when they had a sole intention of creating a child? Mr. Wofford talked about Ms. Carter wanting to be the parent and Ms. Green kind of jumping on that bandwagon. The truth is, if you look at the paperwork from the assisted reproduction, they both participated every step. They both signed every consent. There's paperwork where they're consenting what to do with unused embryos in the case they don't use them all. There's paperwork where they both had to consent to have an embryo thawed and implanted in Ms. Carter. So that, to us, is not just playing along. That is a conscious choice to take this child, this embryo that's been conceived, and to turn this into a child. And so if we're going to say we're going to treat children differently who are born to a same-sex couple, is the rationale going to be marital status? Is it going to be biology? And neither one of those makes a whole lot of sense. And with Mr. Wofford, I think it was Judge Stroud, you were asking about the NCGS 12-13 that says we use the terms husband and wife to be gender neutral. So if you then combine that with 130A 101 that says the husband of the woman who gives birth is presumed to be the father, if we're reading that in a gender neutral way, then the spouse of the woman who gives birth is presumed to be the father or the other parent. So, you know, they talk about in their brief that marital rights have no basis or no bearing on child support. And we say, well, it kind of does and it kind of doesn't, because you know, if you are an opposite sex couple who's not married, it doesn't matter that you're not married. You created a child together, you're both responsible. If you're a same-sex couple who creates a child together, are we really saying the only way you're responsible is if you're married? But if you're not married, somehow you're in a different class than an opposite sex couple who has produced a child through sexual intercourse?
So what I think I heard from your colleague, and I'm happy to be corrected if I'm misstating it, but what I'm hearing is that their position is that if in an unmarried couple scenario, same sex
Right.
or not, that there is the father, the non-biological parent, I guess, would have zero support obligation, irrespective of gender. I think that's what I heard. I mean, how do you respond to that scenario? That there's a gender neutral way to approach this, and that's just to say if you're an unmarried couple that has a child through IVF with a donor, I guess, that there's just no support obligation on the part of the quote unquote non-parent.
And our position is that's not the right thing to do. Whether that is, you know, we've got the one statute that deals with assisted reproduction, that deals with artificial insemination of a wife by sperm other than husband sperm. We don't have anything else. So technically under our statutes, if a husband and wife are together and they use a donor egg and donor sperm, and the child is created outside the woman's body and implanted in the woman, technically that child, under our current laws about assisted reproduction, technically that child, that husband would not have responsibility because we have a specific statute that talks about in what situation husband is responsible for a child born to his wife when not born of his genetic material. So if we have a different situation, is he responsible? Say, well, is mom? And they're defining mom as someone who provides the genetic material or gives birth. And what if you have a situation, and this is not hypothetical, this is a real case I had. 2 women, one provided the egg, one gestated and gave birth. Who is the mom? Are they both the mom? Is neither the mom? Well, for custody, genetic material provider is mom. For child support, are they both mom? Does that mean there can be two moms for child support, or just one mom and one dad? So that is a very long wind-up to, I'm actually going to answer your question, Judge Hampson, is that when two people consciously create a child together, whether they are married or unmarried, those two people should be financially responsible for that child, even if it is an opposite-sex couple who use a sperm donor. And I'm not talking about a situation that Mr. Wofford's worried about where after the fact people come in and say, I think I'm going to help out and be a parent. Does this now put me on the hook for child support? That is, an in loco parentis sort of after the fact. I'm talking about a situation where no child has yet been conceived, and two people say, we are going to make a child. We are both participating. We're both signing paperwork. We are choosing the genetic material to be used, and we are implementing the plan to create a child, that it should not matter whether both of them are providing genetic material, or one of them is providing genetic material, or neither is providing genetic material. I think if two people are dating and they said, we are going to have a child together, we're engaged, we're going to get married, we want to go ahead and get pregnant. Before we get married, we want to create a child together. And they use a donor embryo. Those two people have chosen for this child to come into this world, and so should be required to support the child.
So one of the things, again, I think I heard from your colleague was the concern that, if really all we're doing here in the de facto parent world is just simply applying this sort of like typical third-party child custody piece. And so if we start then just throwing open child support, we might have the situation where, whether it's grandparent or family friend that was coming along and helping to provide support, or even that child had been temporarily left with the family friend, and those types of cases, that we'd be throwing open the doors, potentially broadly to child support actions against, third parties. Am I hearing you try to articulate perhaps a narrower rule that we could apply and our courts could apply?
Yes. I think if we're dealing with a situation where you're talking about a grandparent or a neighbor who takes care of the child, in that case, if you want that person to have some responsibility for child support, you can get into the child support statute and say, is this another person who has assumed the obligation, right? And did the next door neighbor said, look, I'll take your child into my home, I'll support your child while they go to high school. So they'd be in my high school district. Or you guys are having a rough time, you need to go to rehab, I'm gonna take care of the child. Usually there's something written at that point. That is an other person assuming the obligation writing. I'm talking about further back, I'm talking about mother and father, the two people who created the child, not other people jumping in later. Other people jumping in later, we already deal with that. If they are another person who has assumed the obligation in writing, and it's a grandparent or a sister or a neighbor or any of that, what I'm talking about is specifically two people who are, before the child's been conceived, deciding to have a child together, should not be treated differently just because that child's not conceived through traditional sexual intercourse between a man and a woman. So I don't think it's going to have the floodgate, slippery slope situation that Mr. Wofford's imagining in this particular case, because we're dealing with a different situation. He talked about the categories of people responsible for child support, and he said biological parents. Well, the statute actually says mother and father. It doesn't mention biology. We deal with biological issues in custody, but we deal with mother and father. So what I am proposing is we treat mother and father, either we treat it gender neutrally as, mother, father, or it does not mean one mother is all there can be and one father is all there can be. Whether they can be two mothers, there can be two fathers. And both mothers are, if there's two mothers and no father, both mothers are responsible. If there's two fathers and no mother, then there's no mother responsible, the two fathers are. But we do, this idea of biology is tied so closely in custody because we made a decision a long time ago that you have a constitutional right to your biological genetic offspring. And if somebody wants to interfere with that, they've got to jump through some hoops. When you're dealing with cases with same-sex couples who use assisted reproduction prior to marriage, in most of these cases, and I know back when the dawn of this with Mason and Estroff, there are some cases where they didn't choose to do it together. One did it, the other was kind of along for the ride and really didn't have those rights. And that's easy enough to tell from the beginning or pretty early on in a custody case. Was this a joint thing or was this a single thing that somebody else just kind of was there along the way? Here it's very clear it was a joint thing. They had joint maternity photos. And throughout Ms. Green's complaint, she calls herself mother or mama or mom, and says, this is my child. So there is no question that they made the choice together to have this child.
Well, I guess, we can agree, perhaps, that North Carolina's law has not kept up with technology in this area or other developments in this area, and that states who have the Uniform Parentage Act or something of that nature would give us nice answers to these questions. But with the law that we have to work with, we have mother and father in 50-13.4, I believe it is. How do we define mother and father? Do we have anywhere else to look to? Other than, obviously, the term is used a lot throughout the statutes. The terms are used a lot throughout statutes in various different contexts.
Used a lot in the statute.
And obviously, we have clearly adoptive mother, father, we know that. We have biological. Fortunately, we don't have the situation here of a donor egg and a donor sperm and a different surrogate, which can happen.
Could easily happen.
And we don't have that one. But where do we get the definition, mother, father?
So, appellant's definition of mother, I think, was that somebody who provides the genetic material or somebody who actually gives birth to the child. And we say that's way too narrow. And I think mother is a female parent. I think they say father is the male parent. So if we say mother is a female parent and not limited to a female who has either provided genetic material or given birth, then that puts kind of mother and father on par with each other. It doesn't just say father is the male parent, whereas mother has to either provide genetic material or give birth. And I think we don't have the UPA. Maybe, we will at some point. But what I am leaning into is an intentional parentage sort of approach. I've chosen to be a mother to this child. I have chosen to be a father to this child. And how I made that choice was either it was engaging in some kind of activity that produced the child, whether that was sexual intercourse, whether that was choosing a sperm donor, whether that was going and doing all the paperwork and procedures for the IVF clinic, whether it was choosing a donor embryo. We have intentionally created this, and I am a man, so that I am the intentional father. I am a woman. I am the intentional mother of this child for purposes of child support. And I mean, we could get into. I have most of my hypotheticals are really hypotheticals. That first one I said, is actually a case that I had, and I'm not going to get into all of them. But I said that the one that I know existed out in the world, we had a heck of a time in custody because who's the mother and who's the third party? And we represented the woman who gestated and birthed the child, and the other attorney represented the woman who provided the genetic material. And he did a third-party custody action saying, I'm a third party, I'm entitled to custody. And we're sitting here in an office going, actually, you're the mother, and we represent the third party, but we're not going to say anything to you. We're going to let you kind of jump through your hoops over there. But I'm sure he thought that he was right, that our client gave birth, she was the mother, and we thought we were right. Their client provided the genetic material, she was the mother. So there are too many children who are not going to have child support if we stick to a born to a marriage, they get support. Not born to a marriage, they only get support if they were conceived through sexual intercourse. And that's not the purpose of child support. The purpose of child support is to ensure that a child receives support from the two people responsible for its conception and birth. And that is why, however many years back it was, we had unmarried fathers responsible for support. And unmarried fathers have rights to custody. Or saying, at one point where we only had father responsible support back when, presumably the General Assembly figured mothers weren't working and they were the ones who were going to get custody because dad was out doing whatever and he'd had to pay support. But as we evolved to both parents are responsible for support, I think that needs to include both parents, regardless of gender and regardless of marital status. Because, I talked a little bit in my brief, and Mr. Wofford talked a little bit too about the case in the 50B, interpreting that in a gender-neutral way. And in that case, it was interpreted in a gender-neutral way because it said to interpret it differently would be unconstitutional. And to interpret it differently would not serve the purpose. And the question is, for the people who wanted to interpret it exactly as written, can you show us a purpose for interpreting exactly as written? What purpose is served by that? And that's very convoluted, or it's a very convoluted way for me to articulate it. But I think if we take that idea in child support, what purpose can we show? What actual purpose to children or governmental purpose can we show that is served by interpreting everything exactly as is in a man-woman dynamic for two people to have a child? And there's not. It actually defeats the purpose of child support, which is for children to receive financial support from two people.
Is there a difference sort of analytically or how, trial courts address the issue of de facto parent for purposes of custody between the analysis of, I guess, de facto mother or father for purposes of child support? Is there do you see a difference analytically between those inquiries, those questions? And I ask that because it essentially seems to me that the trial court here kind of looked back to the custody order,
Right.
and said, well, under, you've been determined to have custodial rights under under that analysis, and as such, we think you sort of have the same commensurate obligations under the child support statute.
So first I will kind of say, sometimes terminology matters and sometimes terminology doesn't matter. Like I tell my clients in custody cases, if somebody says you have joint physical custody, that word doesn't mean what you think it means. You can have 364 days with one and one with the other and call it joint and call it shared. You can call it, North Carolina custody. You can call it, Mickey Mouse custody. What matters is what you're doing. Joint legal custody, okay, in that context, that has a legal meaning. I think a lot of the words that are used maybe have specific legal meanings and some don't, and maybe they're used in a way other than they should be used. So I think when we're dealing strictly with custody and we're dealing with non-parent and parent, what we mean by those terms is biologically related person and non-biologically related person. I don't think we can take the terminology used in a custody case to say, well, aha, she's already been found to be not a parent. No, she's been found to be someone who is not biologically related, and this is the label that we're slapping on, is because saying the not biologically related party is, we don't want to keep saying that. That is just a lot to say. And we don't want to keep saying the biologically related person. So we say that's the parent and that's the non-parent in terms of custody. And I think that terminology is different when you're dealing with child support. And it is kind of interesting in a way that the child support statutes use the word mother and father and not parents or not biological parents. And mother and father have more of a maybe it's biological relationship, but maybe it's not a biological relationship. You call somebody mom who's not your mother. Maybe it's your stepmom you call her. So mother and father is kind of a weird choice of words, I think, in the statute, and I don't know what they meant by saying mother and father instead of saying.
Back when they adopted
Yes.
this statute, I don't know exactly when, but it's obviously been around for a while.
Right.
Do you think they had any question about what mother and father meant beyond?
Probably
Well,
not.
yeah, obviously, they would have known about adoption.
Probably not.
They would have, because a lot of the technology didn't exist.
Right, and even as Mr. Wofford said, that there's no question who the mother is, that sometimes there's a question who the father is, because they need a paternity test. But the reality is, there
Well,
can't be a
as
question
you
who
say,
the mother
sometimes
is.
there may be a question as to
There
who
can
the mother
absolutely be a
is,
question
right?
who the mother is.
100 years ago, we
Who- I
didn't
mean,
have
who-
that question, really.
Who is the mom? Is the mom the person who provided genetic material, the person who cared for and chose to create the child? And I get this is something new. I don't recall a case that this court has decided that's quite like this. And by asking you to affirm the trial court's decision, we are asking you to do something just, a little bit different. But that is how the custody law evolved through this court, through the Supreme Court. That is how now the 50B law has evolved to be gender neutral and non-discriminating, has evolved through this court, through the Supreme Court. So the idea that this can only be fixed with a legislative fix through the General Assembly, I don't agree with that. This court can take what we have to work with and can use what we have to work with to create something new or sort of new, or repackage it and get to the same result the trial court did, which I think was what the trial court was doing, is taking what we've got and tying that all together and saying, all this tied together, now, it's like if you don't quite have the spice you're looking for, maybe if you put 3 or 4 other spices together, you're going to get the same flavor when you're cooking. So maybe we have all these things, these bits and pieces we're putting together to get to the result, and it's a couple of steps that we have to do. And then once we're there, we're like, oh, okay, is this okay to do it? And the question maybe should be, well, is it okay if we don't do it? And that's where we kind of come at it from the other end, like happened in the 50B cases. If we don't do it, what's the result? If we don't do it, what the result is there are a lot of children who are given an inferior status simply because their parents chose to create, to bring them into being in a different way. And in starting this custody action, Ms. Green started in a position where she was given the advantages that arose from our prior decisions, starting with, Mason, Estroff, and going forward. And so she has reaped the benefit of that and has, equal standing for custody. And in fact, these parties have joint legal custody and they have joint physical custody. So maybe they started out as a biological biologically related person and a non-biologically related person, but by the end of the custody trial, they have joint legal custody, joint decision-making, and 50-50 custody. But, you know, now she's arguing, I want to take advantage of the progress made so that I can, as a non-biologically related person who helped create this child, I want shared joint custody, joint decision-making, but I don't want financial responsibility. And that's dangerous. That to me is more dangerous than any potential, well, what if we have somebody when the child's 5 years old who comes in and helps out? I don't see that as a danger. I see as a danger somebody saying, let's have a child together, and then saying, at this point, I have been given by the court the exact same rights you have, biological parent, exact same rights. You cannot schedule surgery for that child unless I agree, because we have joint legal custody. You cannot decide, potentially what camp this child goes to without me agreeing, because we have joint legal custody. Major decisions I am a part of because I have joint legal custody, but I have no obligation. And so if the direction we've gone is, bless you, two people creating a child together, and one's not biologically related, but they're going to have the same rights, responsibilities need to go along with that. They need to have the same responsibilities. And from the perspective of the child who was created and had no choice in being created, to not have both parties responsible, I said it several times, but I'll just say it one more time, makes these children of a different class or status. Says now these children don't deserve the same support because of how they came into the world. And that's not right, and that with the tools that we have, we can get to the result that the trial court got to, and we can affirm that. And so that's what we're asking you to do, is affirm the trial court's order, finding that they are both mothers for the purpose of child support, and keep that child support order in place. And I've got a minute and a half, and I'm done with what I wanted to say, if anybody has any questions. Okay, thank you.
Thanks very much.
And please, court, the father and mother and any party with legal custody of a child shall be primarily liable for the support of the minor child. That little phrase, and any party with legal custody of the minor child, can be added by the legislature to the child support statute to answer to satisfy the issues that are raised by the appellee in this case. The legislature can make that change simply, easily, quickly, and there that concern is addressed. What the appellee wants is for the court to step in and, through common law efforts, create new child support law that is beyond what the legislature has already created in the statute. We don't agree with Ms. Watts' limited description of our definition of mother. We don't define a mother as a person who is only the person who provided biological material for the child. Under our law, a woman who adopts a child is also a mother, a woman who chooses to adopt a child. Where we do agree with Ms. Watts' argument is that there can be two mothers to a child. There can be two fathers to a child under our current law. A non-biological parent, however, cannot just declare, I'm a parent. The status of being a parent, whether we call it mother, father, or simply parent, is a statutory status that throughout our statutes, there are different ways for a person to be given that status. Adoption is one way. A man marrying a woman who then has a child during wedlock. That's another way to raise the presumption of parentage. All of these things involve a choice by parties who are not the biological parents to become parents of a child and be given that legal status and the legal obligation under the child support law. They have to take steps to become or to be given that legal status. And our statutes provide for those. Ms. Green didn't choose any of those options. She did not choose to adopt this child. She did not choose to marry the child's mother. What she did, and as a result, when it came time for her to file a motion for custody, she was faced with the same, or she was placed in the same role as Ms. Estergy was, as the other mothers in the cases that preceded, or that were in the Gwinnell case, where they were not the biological parent. They were not an adopted parent. They were a romantic partner to the biological mother who had to prove that the biological mother had acted inconsistent with her constitutional rights as a parent in order to obtain any kind of rights.
So when the minor child is in your client's custody, for example, every Thanksgiving in odd-numbered years, who's responsible for paying for the Thanksgiving dinner?
The parent with the child pays the day-to-day expenses for the child in this case.
But isn't that part and parcel of the obligation to support one's child?
That is the in loco parentis type support, right. But what we have here is a case where the judge found that she was primarily liable for the child. So she was treated in the same way that a biological father who may have been married to Ms. Carter would have been treated.
But we also have the situation with this joint permanent legal custody where your client has final decision-making authority for the education of the minor child. Is it your position that your parent or your client can say, you know what, I'm going to require this minor child to attend, the most expensive private school in the state, but I have no obligation to provide financially for that. That's solely going to be on.
First of all, my first part of the answer to that question is that the only reason my client has that ability is because Ms. Carter acted inconsistent with her constitutional rights as a parent, and my client was therefore able to obtain some custodial rights that were in the best interest of the child. So Ms. Carter made choices before the custodial action was determined that my client was able to allege and prove beyond that by clear, cogent, and convincing evidence to obtain those custodial rights. Beyond that, when it comes time to make choices, my client didn't make the choices that the statutes provide for to obligate herself to pay child support to Ms. Carter for the times when the child is in the physical custody of Ms. Carter. That's really what we're talking about here, is the primary responsibility of paying child support on behalf of a child from one parent to the other. And Ms. Carter fought those claims, and as Ms. Watts said, my client said in her complaint that she was the mother. Ms. Carter denied it, and there had to be a trial, and my client had to prove on the constitutional basis not that she was the mother, but that Ms. Carter had acted inconsistently with her rights. And so when it comes time to choosing and making choices, Ms. Green did not make the choices that would have made that claim a lot easier for her. But as a result, it puts her in a position now where she doesn't fall into any of the statutory classes of those who are primarily liable for child support. And again, that's what the court found here at the trial level, that she was primarily liable, not secondarily liable. So we're not talking about the in loco. So for those reasons, we're asking this court to reverse and vacate the child support order that was entered at the trial level. Thank you.
All right, thank you. All right, and thank you both for your arguments, and we will adjourn court.
Did we both leave time on our timers? Neither of us went over time. Did we need to?
That's actually